Hey there, folks. Tonight we're diving into the wild world of eminent domain. This is the government's power to take private property for public use. Sounds intense, right? It is. But hold on, it's not always a bad thing. Think about it. We need roads, schools, and hospitals. Sometimes the government needs to acquire land to build these essential public projects. Eminent domain allows them to do that, even if the property owner doesn't want to sell. Of course, the Constitution requires the government to pay just compensation for the property. This means fair market value, plus any additional damages from the taking. Sounds fair enough, right? Well, as with many things in life, the devil is in the details. The big question is what exactly qualifies as public use? And who gets to decide? That's where things get really interesting. And by interesting, I mean infuriating. Buckle up, because we're about to explore some cases that will make you question everything you thought you knew about property rights in America. For a long time, public use seemed pretty straightforward. Roads, public use, schools, absolutely. But then, things started to get a little murky. What about a shopping mall, or a luxury condo development? Are those really for the public good? Some argue that these projects create jobs and boost the economy, which ultimately benefits everyone. Others say that using eminent domain to benefit private developers is a gross abuse of power. This debate has raged for decades, and two Supreme Court cases in particular threw gasoline on the fire. Get ready to meet our contestants in the battle for property rights. Kelo v. City of New London and Hawaii Housing Authority v. Midkiff. These cases will take us on a wild ride through the tangled web of eminent domain law, so grab your gavel and your outrage because things are about to get real. Our first stop on this legal roller coaster is New London, Connecticut. The year is 2005. The case is Kelo v. City of New London. Suzette Kelo, a homeowner with a pink house overlooking the Thames River, found herself in the crosshairs of the city's ambitious redevelopment plan. New London, facing economic decline, decided to revitalize its waterfront with a massive project that included a hotel, office space, and, wait for it, a Pfizer research facility. Because nothing screams economic revitalization like Big Pharma, am I right? The city argued that the project would create jobs and boost the local economy, thus benefiting the entire community. But there was one tiny problem. Suzette Kelo and her neighbors didn't want to sell their homes. They liked their homes. They liked their neighborhood. They even liked their property taxes. The city, however, wasn't taking no for an answer. They invoked eminent domain, claiming that taking these homes for economic development fell under public use. Kelo and her neighbors sued, arguing that the city was simply handing their homes over to private developers. The case went all the way to the Supreme Court, and the nation held its breath. The Supreme Court, in a 5-4 decision, sided with New London. They ruled that the city's plan, even though it involved private development, qualified as public use because it served the broader goal of economic development. The public reaction was swift and furious. People were outraged that the government could seize homes not for a road or a school, but for a hotel and a corporate research facility. The Kelo decision was widely condemned as a betrayal of property rights and an open invitation for government overreach. The backlash was so intense that it transcended political divides. Liberals and conservatives alike denounced the decision. Even Justice Sandra Day O'Connor, who rarely minced words, called the ruling scary. In the aftermath of Kelo, many states took action to strengthen property rights protections. They passed laws restricting the use of eminent domain for economic development and requiring stricter scrutiny of public use claims. The fight to protect property rights from government overreach had begun. Section 5. Hawaii Housing Authority vs. Midkiff land reform or land grab. Now let's rewind the clock a bit to 1984, long before Suzette Kelo ever heard of New London. This time our legal drama takes us to the Aloha State, where a different kind of land dispute was brewing. Hawaii, with its stunning beaches and lush landscapes, has long faced a unique problem-concentrated land ownership. A handful of landowners controlled a vast majority of the land, while many residents struggled to afford homes. To address this issue, the state legislature passed the Land Reform Act of 1967. This act allowed the state to condemn land owned by large estates and transfer it to tenants living on the land. The goal was to create more equitable land ownership and provide affordable housing options for residents. Enter Frank E. Midkiff, a landowner who challenged the Land Reform Act, arguing that it violated the Fifth Amendment's public use requirement. He claimed that the state was simply taking land from one private owner and giving it to another, with no real public benefit. The case, Hawaii Housing Authority v. Midkiff, landed at the Supreme Court's doorstep. Section 6. The Long Shadow of Kelo and Midkiff. In a unanimous decision, the Supreme Court upheld Hawaii's Land Reform Act. The court recognized the state's legitimate interest in addressing the unique problem of concentrated land ownership. They ruled that the act's public purpose of combating oligopoly and creating more equitable land distribution fell within the realm of public use. While the Midkiff decision predates Kelo, it set the stage for the broader interpretation of public use that would later inflame the nation. Both cases highlight the tension between individual property rights and the government's power to act in the name of the public good. These cases raise fundamental questions about the limits of government power and the meaning of property rights in a modern society. They force us to grapple with the difficult balance between individual liberty and the collective good. And they remind us that the fight for property rights is far from over. Section 7. A patchwork of protections, state laws step in. After the Kelo decision, a wave of outrage swept across the nation. People were furious that the government could take their homes for economic development projects that might or might not benefit the community. State legislatures, sensing the public's anger, sprang into action. Many states passed laws that restricted the use of eminent domain for economic development. Some states required stricter scrutiny of public use claims, making it more difficult for the government to justify taking private property. Others banned the practice of transferring condemned land to private developers. This patchwork of state laws has created a confusing and inconsistent landscape for property owners. In some states, property rights are strongly protected, while in others, the government still has broad powers to seize land for economic development. The fight for property rights has become a state-by-state battle. Section 8. The fight continues, eminent domain in the 21st century. Despite the backlash against Kelo and the passage of state-level reforms, the threat of eminent domain abuse persists. From pipelines to stadiums, the government continues to invoke its power to take private property for projects that some argue primarily benefit private interests. The fight over the Atlantic Coast Pipeline, for example, pitted energy companies against landowners who were unwilling to give up their property for the project. Similarly, the construction of new sports stadiums often involves the use of eminent domain to acquire land, displacing residents and businesses in the process. As we navigate the challenges of climate change, infrastructure development, and economic inequality, the debate over eminent domain is likely to intensify. Balancing the need for public projects with the protection of individual property rights will continue to be a delicate and contentious issue. Section 9. Protecting property rights, lessons from Kelo and Midkiff. The cases of Kelo and Midkiff offer valuable lessons about the importance of vigilance in protecting property rights. They remind us that the government's power is not absolute, and that citizens have a right to challenge government actions that infringe on their fundamental freedoms. These cases also highlight the need for clear and robust legal protections for property owners. Vague definitions of public use and weak judicial oversight create opportunities for abuse and leave property owners vulnerable to the whims of government officials. Ultimately, the fight for property rights is about more than just land or buildings. It's about protecting individual liberty, ensuring fairness, and limiting the power of the government. It's about ensuring that the American dream of homeownership remains a reality, not a distant memory. Section 10. Conclusion. The delicate balance of power. Eminent domain is a powerful tool that can be used for good or for ill. When used responsibly, it can facilitate the construction of essential public projects that benefit everyone. But when abused, it can become a weapon against individual rights, displacing families, destroying communities, and undermining the very fabric of our society. The cases of Kelo and Midkiff serve as stark reminders of the importance of striking a delicate balance between the needs of the many and the rights of the few. They challenge us to think critically about the limits of government power and to demand transparency and accountability from our elected officials. As we move forward, we must remain vigilant in protecting property rights and ensuring that eminent domain is used sparingly, judiciously, and only as a last resort. The future of our communities and the very soul of our nation may depend on it.